Well, hello everyone, and welcome to Insight with political tours and beyond the headlines. The United States Supreme Court has just completed one of its most remarkable terms in years. It has torn up Roe versus Wade, expanded gun rights, restricted environmental law, and looks likely to give states the ability to further restrict voting for some people. There's no doubting the impact of President Trump's 3 appointments to the bench. But how did we get here? David Cole, National Legal Director of the American Civil Liberties Union, is here to outline the enormous changes to the court over the past 50 years and look at its most recent decisions. Hello, and thank you very much indeed for joining us, David.
Thanks for having me.
Let's just start at the top. I mean, it's been a momentous week and a bit. And it's quite difficult to take it all in, particularly if you're looking outside outside of the states looking in, as it were. Can you just give us, just run through some of those decisions? Let's just start with Roe versus Wade.
Right. So this is certainly the most conservative term of the Supreme Court in my 40 years as a constitutional lawyer. And according to the New York Times, it's the most conservative term in the last century for the Supreme Court. So it's quite a remarkable turn of events, largely because of the change in makeup on the court. But it manifested this term in decisions overturning the right to abortion, which is a 50-year-old constitutional right, which has been affirmed in and reaffirmed in 20 or more decisions since Roe versus Wade was decided in 1972 or three. The court also struck down a restriction on carrying guns in public that was in place in New York State for over 100 years. The court ruled that a public high school is required to allow its football coach, that's American football, its football coach to pray publicly on the 50-yard line after every game, even if the school is concerned that doing so will suggest that it's endorsing his Christian beliefs or that it will coerce players who want to play to pray to play. The court struck down an Environmental Protection Agency rule that required producers of electrical power to shift away from coal sources, a critical aspect of our response to climate change and global warming. And it did so on the basis of a newfound doctrine that it has created called the Major Questions Doctrine, that essentially is very skeptical of administrative agencies and requires Congress to specifically authorize particular actions that agencies take that are significant, whatever that means. So it's a pretty remarkable term. Court ruling on abortion, guns, religion in public schools, and frustrating critical efforts to address global warming. And all of those decisions, either 6-3, with all the Republican appointed justices on one side of the line and Democratic appointed justice on the other, or 5-4, situations in which one Supreme Court justice might go along with the liberals, but generally an extraordinarily conservative term.
It is quite remarkable in that if you go back to the 60s and 70s, Earl Warren is the Earl Warren Court is seen as introducing many of the civil rights era changes that gave many of the rights that you're concerned with. But that took place over a period of time. So the fact that these decisions took place in such a concentrated burst of time is quite extraordinary, isn't it?
Yeah, absolutely. And particularly the abortion decision. I mean, President Trump nominated 3 justices to the court. He made it an explicit litmus test for his appointments, that he would appoint people who would overturn Roe versus Wade. He essentially promised that in his presidential campaigns. He then appointed 3 justices. they came onto the court, and in really their first full term as all three being on the court, because Amy Coney Barrett was the last appointee, and she joined just after the prior term had started. So this is the first full term in which they had the full three Trump justices, and they took an abortion case that they didn't need to take because they have discretionary jurisdiction. They don't have to decide any cases. They pick and choose what they want to decide. They took this case. They reached out to overturn Roe when they didn't need to overturn Roe. In this case, Chief Justice Roberts he joined the opinion to uphold the law that was challenged. It was a law banning abortion after 15 weeks of pregnancy. But he did not join the 5 justices who said overturn Roe versus Wade. And his argument was, we don't need to decide whether to overturn Roe versus Wade. Roe versus Wade and its progeny basically say that the states cannot impose an undue burden on women's right to terminate a pregnancy. He argued 15 weeks is not an undue burden. If a woman has 15 weeks to decide whether to terminate a pregnancy, that's a reasonable amount of time. And so we can uphold this law without overturning Roe versus Wade. And the majority, the 5 justices, just aggressively, unnecessarily reached out and said, nope, we are declaring that Roe versus Wade is overturned. And it is a truly unprecedented decision in that it eliminates a constitutional right.
Yeah.
Eliminates a constitutional right that fully half the country has depended upon for their equal status in this nation. So the court does the court overturn prior decisions? Yes, rarely, but it does it. But on what grounds? I mean, ordinarily, when the court overturns precedent, it is expanding rights. It's saying, actually, we recognize the Equal Protection Clause does extend to women, even though we previously said it didn't apply to women, or does protect gay and lesbian folks, even though previously we said it didn't, or does provide that racial segregation violates equal protection, even though we previously said that it doesn't violate equal protection, right? Those are all expanding rights. It's a very different thing to have given a right, to have recognized a right, said this is a core part of who you are as an American citizen. You have the right to decide whether to have a child or not and whether to terminate a pregnancy or not, and then to take that right away. Take that right away. And so that is a remarkable thing. And to do so sort of as soon as they get on the court, to basically do President Trump's bidding, really risks politicizing the court. The court is supposed to not be a political body. It's not supposed to vote along partisan lines. It's not supposed to do the bidding.
And that's what all 3 dissenting judges said in a unified opinion, where they disagree with the majority opinion, in which they said this would undermine the court if you have the newly appointed justice and then just introducing this or seeking to turn over Roe versus Wade straight away as soon as those justices are appointed, clearly showed that there would be political influence, or that would be indicative of political influence. Why do you think they were so keen to try and do it so quickly? It seems to be they've done it as soon as they could.
Well, I think, that is a great question. I and many others predicted that they might cut back on Roe versus Wade, that over time they would chip away at it, but that they wouldn't overturn it so dramatically and so quickly because, it doesn't look good for the court to do that. It looks like, you just change the personnel on the court and constitutional law changes. That seems problematic. I think it's a couple things. I think one is that they have, these are all, if I'm not mistaken, the 5 justices in the majority are all either Catholic judges or judges who were raised Catholic. Wow. One of them, Gorsuch, apparently goes to an Episcopalian church, but he was raised Catholic. He went to a Catholic, school, etc. All the others are Catholic, and so they care about this deeply as a moral matter, as do many Catholics. And so I think they may have been driven in that way. That's a totally inappropriate basis, I should, make clear, for a constitutional ruling.
Yeah.
But I do think that has something to do with it. The other thing is that these 5 justices, it's Justice Clarence Thomas, who's been on the court for a long time, and Sam Alito, also on the court for a pretty long time. And then the 3 Trump appointees, Brett Kavanaugh, Neil Gorsuch, and Amy Coney Barrett. They all subscribe to this particular theory of interpreting the Constitution, which is called originalism. And the idea is, the Constitution is like a contract. You enforce the contract by its terms as they were understood at the time that the document was drafted.
And this just to interrupt you, because this deals with your question now. If we're talking about, I wanted to know, what is the basis, what is the justification for all these significant decisions, and this originalist drive of interpreting the Constitution that way if they talk about the Federalist Society, talk about this, it's trying to move back the pendulum over the expansionist era of the 60s, 70s, and since then, that have provided rights that they see as not being founded in the Constitution. So their perception of your definition of those rights is too expansionist. The rights that have emerged over the last 50 to 70 years have been too much, have gone beyond what the founding fathers meant. And that's the sort of conservative argument that enables them to wipe out the things that you've outlined.
Right. But the problem is, it's not just the last 50 or 70 years, it's the last 200 years. There have been on the Supreme Court about 116 justices over the course of its history. Of those 116, maybe 6 or 7 subscribe to an originalist view of interpreting the Constitution. 6 or 7. The 5 who are on the court right now, who I just mentioned, sometimes Chief Justice Roberts, so that's 6, and then Justice Scalia, Anthony Scalia, who died a few years back, but was a very vocal proponent of originalism. But if you look at the rest of the 110 or so justices on the court over the history of our country, they're not originalists. They all have adopted the same way of interpreting the Constitution, which is to say, you start with the text and you start with the original understanding, but the text was written with the idea that it would govern the nation for centuries. And so the framers used broad, open-ended terms like due process, equal protection, cruel and unusual, liberty, with the idea that if this document is really going to, be the founding document for the nation, it has to evolve over time. And so it has evolved over time. All of those provisions have evolved over time through, the ordinary, completely familiar way.
So, just to state the obvious, and here's a contradiction: the Constitution enabled you to own slaves back in when it was first written. Is that right?
Oh yeah. Yeah, I mean, it was until the Civil War. But
it didn't state anything about abortion, and so therefore.
No, it didn't state anything about abortion, but it didn't state anything about forced sterilization either. But that the court has said that forced sterilization is not permissible. Didn't say anything about the right of parents to educate their children, but the court has read the liberty provision of the Due Process Clause to protect that for over 100 years. Didn't say anything about the right to contraception, but the court has read that to be protected by liberty. Essentially, what the court has done, again, over 100 justices, almost all the justices in the history of the court have said, we take these provisions, we look at them over time, we apply them to the changing conditions in the country and the evolving norms in the country. And that's how we make the Constitution our Constitution today, not just the Constitution of a bunch of dead white men who signed it 200 years ago. And that's the only, that is not the only way of reading the Constitution, but that is the majority way of reading the Constitution by virtually every justice, except for the 5 who are currently on the court. But because they're 5 and they're currently on a court of 9, they have a majority vote. And so their argument for why Roe was egregiously wrong, why the right to abortion decision was egregiously wrong, was that it didn't apply this historical approach to the Constitution. But neither has any other decision on the Supreme Court for 200 years been restricted to this strict historical approach. And so if you're going to say that, you're going to be upending boatloads of constitutional law because it, and I think it's a lot of hubris, right, to say this decision was egregiously wrong because it applied a theory for reading the Constitution that over 100 of our former colleagues on the court have applied. But because we think, we 5 and 2 others, think that there's a new way of interpreting the Constitution, that makes the decision egregiously wrong? No. I mean, what the court said in Roe and its progeny was basically, look, liberty is protected by the 14th Amendment of the due process of the Constitution. It says no state shall deprive anyone of liberty without due process. So what does liberty mean? Well, you have to inform that term with our basic understandings, and what they've said that means is bodily integrity, the right to control your own body, and personal autonomy, the right to make critical personal decisions by yourself and not have them made by a bunch of politicians, like whether you have who you have sex with, who you marry, how you raise your kids, and when and whether you have children. So
David, I want to understand if you live in most other democracies, parliamentary, presidential, whatever system you've got, the court generally doesn't take such an important role in the political life of a country. The Supreme Court has its role has grown more important over the last century and plays a critical role. So can you make the distinction? Because I think it's got a constitutional role, but it's also looking at law as well. It's got a sort of dual role that I don't think exists in other countries.
Well, it has the power of what we call the power of judicial review.
Yeah.
Which we mean something different from the English, but what we mean by that is the power to declare an act by the political branches, whether by the president or by Congress or by the Congress and the president acting together or by state politically, unconstitutional, right? And that's a big deal. It has the final say on the constitutionality of political actions, whereas in a lot of other countries, that power is not given absolutely to a court. You take the British Supreme Court. They exercise a power of judicial review, but their actions are generally can be overridden by the Parliament.
Yeah.
That is not true with respect to constitutional law in the United States. The only way you can override a Supreme Court interpretation of the Constitution is by amending the Constitution itself. Yeah. And it's very, very difficult to amend our Constitution. Yeah. It's only been done 29 times in the history.
And that's what the founding fathers intended in the balance of powers. And I think a lot of us are familiar with that. But I think perhaps what people are less aware of is that if you go back to the 40s, 50s, if you go back to the earlier part of the 20th century and before, the court did not have such a controversial role. And certainly in terms of the appointment of justices, it wasn't a political football.
It wasn't as much a political football. That's certainly true. And I think so. I think that one of the big shifts. There've been a number of big shifts with the court. One was in the 1930s when the court was essentially on the side of business and consistently striking down laws that sought to protect workers and consumers against exploitation by big business. And there was a real attack on the court at that time because we were in, it was the Great Depression. People needed laws to protect them. The court was striking them down. The president at the time, Franklin Delano Roosevelt, actually sought to pack the court, to add justices to the court, to change its political ideology, to uphold some of the laws that were being struck down. And the court eventually shifted its view and became more deferential to social and economic legislation, and not striking down laws that sought to extend rights to ordinary folk, on the claim that they violated business owners' rights of property or contract. So that was one big shift. The second big shift was during the Civil Rights era, when the court interpreted the 14th Amendment of the Constitution, which was adopted after the Civil War, to essentially apply all of the Bill of Rights to the states. And that was a big deal because the Bill of Rights, as it was initially adopted, the one that people are, probably vaguely familiar with, it protects the free speech, free religion, the right to bear arms, and all the rights of criminal defendants and the like. That was initially enacted and applicable only to the federal government, not to the state governments. And a lot of law enforcement in the United States is done at the state level. The police tend to be state level, the property laws tend to be state level, et cetera, et cetera. So if the court was only sort of declaring constitutional rights vis-a-vis federal legislation, didn't make that much difference. Once it starts, it was a big deal, but it didn't have such broad powers. Once it starts applying all those norms to the states, and that really did happen sort of the 50s, 60s, 70s during the Civil Rights era, when there was so much abuse of state power, and the courts basically stepped in to try to stop it. So then the court becomes much more significant.
Politically very significant. And if you're looking at it from the right perspective or the conservative perspective, then the court's composition becomes a problem. And then from the 1980s, that's when you begin to get the prioritization of who's going to be the next justice, where do they come from, and what are their values? Well,
yes, but the court has had a majority of Republican appointees since 1972. 1972, 50 years, it's been a Republican-dominated court. So it's never been, the Warren Court was the last court that was really dominated by liberals. It's for half a century, it's been dominated by conservatives, but that wasn't enough for a particular, part of the right wing in the United States, which felt that, some of the people that they'd appointed as conservatives turned out to not be conservative enough, turned out to be too moderate, turned out to be too open to things like same-sex marriage or abortion or, the rights of criminal defendants or striking down the death penalty for juveniles. These are all things that certain conservatives were opposed to. And so, in the 1980s, a group called the Federalist Society was created. It was actually, it was created by a law school classmate of mine in the 1980s at Yale Law School. And, at the time we thought this is, these guys are outliers. They're, nut jobs. Sure, they've got their Federalist Society, but, they're so far out of the mainstream. But they were very, very persistent, and they were also acting kind of in a vacuum. There was a fair amount of civil society legal institutions on the liberal side, like the ACLU and the NAACP Legal Defense Fund, and some would say even the American Bar Association had a kind of liberal bent. Most of the law schools had a liberal bent. So there weren't that many conservative institutions in this space. And so they kind of had a monopoly, and all the conservatives gravitated to them, including a lot of, people with a lot of money, a lot of rich people who are conservative because they want to conserve their resources. And so the Federalist Society grew more and more powerful, and it became, a more and more rigid kind of ideological place. And when Trump was elected, he basically delegated to the Federalist Society the picking of judges. And also one other thing that happened that's really quite significant, which is that until near the end of the Obama administration, in order to get a judge confirmed by the Senate, the way the judges are appointed is the president picks them, but then the Senate has to confirm them. And if they don't get confirmation, they don't get put on the court. This is true for the Supreme Court. It's also true for the federal appellate courts and the federal trial. And until late in the Obama administration, you had to get 60 votes in the Senate, which has 100 members. And oftentimes what that meant was you had to get some support from the other party, because it was rare that one party would ever have more than 60 votes. We tend to be very closely divided, Republicans and Democrats. So for a long, long time, you had to, if you were a Democratic president, you had to get some Republicans to support your nominees. And if you were a Republican president, you had to get some Democrats to support your nominees in order to get them on the court at all. And what that meant is that you were sort of forced to pick more moderate folks. During the Obama administration, the Republicans took control of the Senate, and they started blocking every appointment to a Court of Appeals judge, and with this 60 vote rule, and the Democrats finally got rid of it because they said it's dysfunctional at this point. We can't put anyone on, even though we have 50 votes. We can't put anyone on. So they got rid of the filibuster. So the filibuster is no more. And then Trump came into office, and what that means is if you've got a president and a party of the same, of the Senate control the same party, you can just put on anybody you want because you know.
I mean, David, you've got to say that then the Democrats are responsible in part for this mess. I presume.
Oh, sure. I mean, both sides are responsible for the mess. I mean, it was driven by, I think that the Democrats were not eager to do this, and they resisted and they resisted and they resisted doing it. But the Republicans were so sort of obstructionist that it was dysfunctional. And so at that point, you kind of it's like now people are saying, look, we need to get rid of, we have the similar rule for legislation. And people are now saying we should get rid of that rule because Congress is dysfunctional. If every time the opposing party refuses to support anything that the other side does, it's dysfunctional. So, but in any event, what that meant is that Trump had a free ride. He delegated that authority to the Federalist Society, and they, packed the courts of appeals and the Supreme Court with very, very conservative judges, many of whom would not have been confirmable, prior to in the old days. And Biden has also had that. Biden has a 50 vote and 51 vote majority in the Senate, and so he too has been able to appoint much more liberal judges than would have been confirmable before, because you don't have to get any support from the Republicans. It has led to the appointment of more extreme judges than was ever possible before.
I think it's worth also remembering when Obama tried to appoint Merrick Garland, that the Republicans simply wouldn't have the hearing and waited until the Obama's term was over, and then obviously when Trump came in, they had a chance to put in the seat instead, which it seems pretty outrageous, a stolen seat, if you will. But
I mean, people are very upset about that. There's nothing technically illegal about doing that. You have to get Senate confirmation if the Senate refuses to give confirmation. But never before had the Senate just refused even to consider somebody for a year. They sat on it for a year. And then, of course, when it was the end of Trump's administration and Ruth Bader Ginsburg died, a liberal justice, former ACLU lawyer, when she died just, a few months before the election, the same McConnell, rammed through the appointment and confirmation of Amy Coney Barrett in a matter of, less than 2 months, I think. So, what's sauce for the goose is not sauce for the gander under this approach.
For all the lauding of Beta Ginsburg, don't you think that if, from a liberal's perspective, she should have stepped down in the first part of Obama's, or first Obama presidency, at least when there was a guarantee of getting another liberal on the court?
Yeah. Yes. I mean, hindsight is 20/20, but
well, it's not hindsight, surely.
Well, it is hindsight. I mean, if she had lived another 3 or 4 months, it would have been fine, but she didn't.
Yeah. Okay. So I mean, I've got tons more questions. I'd love to get questions from people. You start putting, everyone, if you've got your the Q&A box down below at the bottom of your screen, please start putting the questions in your the Q&A box, so we can put your questions straight to David. I've got tons and tons more things to ask you. Just to start with, what's next? There's a new theory that I gather the court is looking at that could change, give states the ability to restrict voter rights, and that's all about the state legislature. And it's complex, but it needs explaining. Yeah.
So next term, I mean, this term was a blockbuster term with guns. I mean, they issued the gun decision. We haven't really talked about the gun decision, but I mean, talk about foreign to your audience. I mean, first of all, the notion that we have a right to bear arms.
But I mean, let's talk about that. And also the dismissing of the senior justices there dismissed the fact that they. In the counter opinion, they say that the evidence shows that the number of gun incidents is clearly very concerning. Statistically, evidence and research shows that gun ownership is having a terrible impact on the American people. They dismiss it.
You only need to read the newspapers to see that. I mean, it's incredible.
And they explicitly dismissed that evidence in their ruling.
Yeah, they said the only gun laws that are permissible today are those that have a direct analog in laws that were in existence at the time that the Second Amendment was adopted in 1791, or maybe when the 14th Amendment was adopted in 1868, because it extended the Second Amendment to the states. But basically, you have to point back to the 19th or 18th century and say, well, here's a law that looks like the law that we're enacting. And so therefore, even though obviously, the circumstances on the ground have dramatically changed. We have 400 million guns in the United States. You can get them over the internet. Kids can get them. They're extraordinarily high powered. People live in urban settings where they have police to protect them. When the Second Amendment was adopted, people lived in very rural areas. There were no police forces. And so, people protected themselves with guns, but that's changed dramatically. And the court basically says, no, you are stuck. You today, states, are stuck to what was done in the 18th and 19th centuries. And it doesn't matter how much gun violence is a problem. It doesn't matter how many people are dying, unnecessarily and cruelly in this country. We don't care unless you could point to a historical analog. And then in the case, the New York, which had passed the law, pointed to dozens and dozens of historical analogs, because it probably shouldn't be a surprise that states and governments have long sought to limit the ability of people to carry guns in public, and that's not something that states generally want. It's just like armed citizenry walking around carrying guns. So there were lots of historical analogs, and with each one of them, the court said, "Oh, that's different because it's too old. Oh, that's different because it's too recent. Oh, that's different because it was adopted for a different reason. Oh, that's different." I mean, they just distinguished every one of them, often on internally contradictory grounds, to reach the result that no, New York could not require people to show they have a need to carry a gun before giving them a permit to carry a gun. So this isn't
an academic point, but the one hand, what I'm trying to get my head around is, on the one hand, they give the state the right to interfere in a woman's life and say, this is what you should have to do. And yet at the same time, they say the state cannot provide for safety on the streets and a threat to your daily lives.
No, it's astounding. And, so we'll see what that, but it's another instance in which the court sort of elevates this commitment to history, to 18th century and 19th century history, and basically uses that as a straitjacket to restrict people's rights and safety today. So very, very troubling. But anyway, this was a big term, but next term is going to be a big term too, because next term the court has agreed to decide some really blockbuster cases. Is affirmative action constitutional? Is it constitutional for universities to take race into account in deciding who they, admit? Hugely controversial issue. They're going to decide that issue. They're probably going to say it's unconstitutional. It's been, a core part of this country's practice for, decades. And, without it, you're going to have, virtually no African American students in a lot of the top universities in this country. They're deciding a case that they almost decided a few years ago. I actually argued the case, and I know there's been a similar case decided in Britain. But does a business have a First Amendment speech right to refuse to provide a service to a gay couple because it's opposed to that gay couple's desire to celebrate their wedding? This is somebody who provides wedding website services and doesn't. There's another case that challenges the constitutionality of the Indian Child Welfare Act, which is a statute Congress passed some years ago to try to keep Indian children in their tribes rather than allowing them to be sort of taken out of their tribes and put in the broader general public, which has has had a very negative effect on the continued existence of Indian tribes, which have been long discriminated against. And then they've taken up a couple of cases involving racial gerrymandering. And when racial gerrymandering, that is when the states create districts to suppress the ability of Black voters or Latino voters to elect candidates of their choice by packing them all in one district and then making all the other districts majority white. It's taken up a couple cases that address that very, very controversial question. And then finally, this independent state legislature doctrine that you just alluded to, which is one that would say that basically state courts cannot tell legislatures that they've violated the law with respect to how they run elections for federal office. And that would be disastrous because, what we've got right now is sort of Trump-like aficionados running for office on, the myth of voter fraud and that the 2020 election was stolen. And they're running for the offices that would allow them as the legislature to ignore the popular vote and to, put in office somebody like Donald Trump, who clearly lost the popular vote.
That last one's extraordinary. I mean, I know theoretically in Britain, with a parliamentary majority, you could, the court makes a decision about legislation and you change the legislation and that's the law. But there's no constitution about it. But I can see that the precedent with, Republican, there's a long record of legislators gerrymandering districts as it is in the states. And the idea that those things can't be challenged by any other body is pretty frightening. We've got some good questions coming through. So let's start with Diane Cook. Go ahead, Diane.
Hi. I may be confusing things here, but are you saying that the current majority on the court is really saying they can only look at the words written in 1787 and the subsequent amendments, and that they take no notice of precedent? So the concept of common law, does that apply to constitutional law or not?
That's a good question.
It's a great question. So I think, we'll see how far they take it, but that's basically the idea. The Roe versus Wade was an application of common law constitutionalism, taking a line of precedents that had interpreted the term liberty and applying it to a new question and concluding that, yes, this decision about whether to terminate a pregnancy is sufficiently like decisions about whether to use contraception, decisions about who to marry, decisions about, whether you can be forcibly sterilized, that it is also protected. they didn't, they also, the court at the same time recognized there was a competing interest of the state in the fetal life of the fetus, potential life of the fetus, but it weighed that against the right. That was a common law constitutional approach that is precisely what I was saying. The over 100 justices have employed for the last 200 years. This majority sometimes applies that approach. They're not consistently historical. Sometimes they use that method. But in other instances, this claim of historical interpretation arises in which you're not allowed to do that. And that's what they said with respect to the gun case. That's what they said with respect to Roe versus Wade. They said that in addition in the football coach praying on the field, even though, in that case, they said, well, the prior precedents have said you ask questions like, if you allowed the coach to do this, would it be seen as the government endorsing religion? Those kinds of questions. So that was a doctrinal test that had been developed in a common law way. The court said, no, we're not going to ask that. We're just going to ask whether there's a history and tradition that prohibits this sort of activity. And since there wasn't a history or tradition of, football coaches praying on the 50-yard line at all, there wasn't a history or tradition that prohibited it, and therefore the state was required to allow it. So it's a, it's a very, very, as I said, it's an outlier theory of interpreting the Constitution. It's not one that even they apply consistently, but if it were applied consistently, it would uproot much of constitutional law in the United States.
Yeah, incredible. Fran Hoffman. Go ahead, Fran.
Yes, thank you. You speculated earlier on motivation for the anti-abortion stance of the current justices and theorized that it may stem from deeply held Catholic faith traditions, which I understand, don't necessarily agree with. But I search in vain for the zeal with which the pro-gun issue is tackled. What would you theorize to be going? What are the foundational values at stake there for the justices?
What a good question. So yeah, I mean, I would have predicted that conservative justices and liberal justices would unite in the notion that we don't want guns run rampant throughout American society. That, if you're part of the establishment, if you're part of the government, it's just not a great thing to have a citizenry armed to the max. And we see the results of it, every day. There was just on the 4th of July, another mass shooting in a town that was just, 2 towns over from where I grew up as a child in Illinois. So what is going on? I think one I'd say 2 things. One is ideologically, it's part of the kind of American individualistic frontiersman, ethos, every man to himself, self-defense. I can
freedom of the individual from the tyranny of the state.
Yeah, I can protect my castle with my gun, et cetera, right? There's that kind of mythic image of the frontiersman with his gun, which I think has some appeal to a lot of people. The other thing, though, is that there's an organization in the United States called the National Rifle Association, the NRA, which has been around for over 100 years, and was for most of its time really just hunting and shooting. But in the 70s, it decided to really try to develop this notion of a constitutional right to bear arms. And at the time, there was no constitutional right to bear arms. The then virtually unanimous view of the Second Amendment was that it protected the rights of states to have militias to sort of fight against or ward off the tyranny of the newly created federal government. That was what we were concerned about. And so the Second Amendment is written with a preamble that talks about the right of states to have militias. And that was all it was understood to protect. In fact, a conservative Republican-appointed Supreme Court Justice, Chief Justice Warren Burger, appointed by Nixon, I believe, although I'm not
Nixon,
sure there.
yes.
Yeah. He said in 1976 or thereabouts that the notion that the Second Amendment protects an individual right to bear arms is one of the greatest frauds perpetrated on the American people in his lifetime. And who was perpetrated that fraud? The NRA, which had just sort of in the early 70s decided to make this a program. But they did it in a very committed, careful, incremental way, first establishing the right in state constitutions and state laws, then getting some academics to sort of question the historical understanding, and then getting their membership. They have a massive membership to basically vote, on this issue. So you would vote they would support the candidate in whatever election who was better on the right to bear arms, single issue voting, and they did. And so it became extraordinarily politically powerful on the right. And it became very, very hard if you are on the right to be opposed to the right to bear arms. And then they eventually got, justices appointed who came out of that right wing in which it was, sort of apostasy to oppose the right to bear arms. Mm. And so that, so there you have it. But it's justified. And if you read the opinion, it's justified on the ground of, well, this is what the history was about. But what they don't say is that for 150 years, we had a totally different understanding of that history, totally different. And so, what changed it was the NRA organizing, making this a political issue, working through the institutions of democracy, and I don't blame them for doing that. I think, that's how civil rights and civil liberties are actually best protected, by organizations like the NRA or like the ACLU, for whom I'm the legal director, getting people together and exercising their liberties to defend the rights and values that they believe in. And if you do that effectively, you can be very successful. It's been true of the ACLU over time. It's been true of the NAACP Legal Defense Fund in getting Plessy versus Ferguson overruled and segregation outlawed in this country. It's true of the NRA. And now it's true of the anti-abortion movement.
David, in a second, I want to come to the question is, how do you respond to this? I mean, you very good at taking cases to the court, but if the court's stacked against you, and it is, that's quite openly with a number of the justices and their declared opinions, by and large, they're against what you stand for. So going through the processes of taking cases to the court is not going to work it's not going to work now. The strategy that the Republican right have had is to say, right, we are going to change the system. We are going to make sure that we've got the justices who've got support us are going to be in the court. It seemed to me that that there's an organization, I think it's called Demand Justice, which has talked about increasing the number of justices in the court so that you could stack the court, just as Roosevelt did, with more liberal justices. So my overall question is, how do you challenge this? I mean, it seems to me that you've got major decisions, more decisions coming. They're going to undermine the rights that you stand for. How do you prevent it from happening?
Yeah, so I don't know that you can prevent it from happening, but you can certainly fight, and you can change things over time if you do fight. So, look at the anti-abortion folks. When Roe versus Wade was decided in 1973, they didn't say, oh, that's it. The Supreme Court has ruled, it's over. They organized, they lobbied, they got people to vote on these grounds, they got people appointed on these grounds, and they were successful in overturning Roe versus Wade. The same thing is true of the NRA with the right to bear arms. The same thing is true with the gay and lesbian movement with respect to the right to marry in this country. The same thing is true with the ACLU and the extension of equal protection to women.
Okay, I get that, but that's a long term. You're talking about years, terms, decades.
That's what we're talking about.
In the meantime, you could see things like gerrymandering taking place on an enormous scale, gay marriage rights being overturned. America, I mean, I hate to use these terms because I don't like to pursue cliches, but entering from a liberal rights perspective, and America entering a very dark period of history, and for quite some period of time?
So that depends. It depends on how people react. If people sit back and say, well, my God, there's nothing we can do. There's now 6 conservatives on the Supreme Court. It's over. Yeah. Well, then there's not going to be much that will stop the court from doing a lot of damage. But if we push back, if we fight back, if we organize, if we vote like our rights depend on it, if we get state courts to protect our rights, if we get state legislatures to protect our rights, if we get Congress to protect our rights, the court will respond. I mean, what history shows in this country is that the Supreme Court has rarely deviated from where the country is on fundamental issues. And in those instances where it has corrected itself because of popular opposition and popular resistance. And so that's what we have to do. And will it be long term? Yes, it'll be long term. And will there be a lot of hard pain and suffering in the short term? Yes. But we can also try to, do things to resolve that, reduce that pain and suffering. There's going to be many states that will protect abortion and many states that won't. And so one thing people can do is support, women who are in states that don't allow abortion, support them by, providing the funds that allow them to go outside of the state to a neighboring state, just like people used to have to do in Ireland, and they would come to England to get abortion. So, there are sort of short-term things you can do, but ultimately, it's about, I think, using our civil liberties to push back. I don't think we're going to pack the court. After you referred to FDR, he tried to pack the court. He failed. He was one of the most popular presidents in U.S. history. He was president at a time when the court was extraordinarily unpopular. The country was under tremendous stress because it was the Great Depression. And every time a state or a federal legislature passed a law protecting people from business in a depression, the court would strike it down. And even then, FDR never had majority support for packing the court. Eventually, the court changed its vote without being packed, and so it never had to happen. So I don't think packing the court is a realistic goal. But I think, protecting abortion as much as we can and as far as we can in those states that recognize it, using state constitutions, because in the United States, the federal constitution is a floor, and states cannot violate federal constitutional rights, but states can provide greater rights. And many, many states do than the federal constitution does. And so, we just filed suit in Kentucky, in Florida, in Utah, all of which the legislatures sought to ban abortion, and we filed suits on. But
conversely, you're going to see Republican states go the other way, and
those are Republican states. Yeah, Florida, Kentucky, Utah, those are Republican states, and nonetheless, we got courts, at least at the trial level, to say no, the state constitution protects this right. So whether that will be upheld when it goes up on appeal, we'll see. But we're doing everything we can in every forum we can to preserve and protect these rights. And I also think the court will respond. If there's a real outcry, if people really vote along these grounds, the court will, take heed. They will say, oh, well, I guess, because at the end of the day, they depend on their legitimacy. And their legitimacy has just taken a real hit. I mean, the polls have, they've gone from the most trusted institution in the United States to basically
at the same time you see the likes of Alito and Thomas saying that's not our issue. It's not a question of whether the court or not the court is popular or that the public approves of what. Well,
of course they're going to say that, but they also go out. They spend a lot of time going out making speeches trying to defend the court's legitimacy because they understand. It actually matters. If people start to perceive the court as illegitimate, what power does it have to enforce its actions? Its power to enforce its actions is that it is seen as legitimate. And if it loses that, it has no power. Can't call out the army.
We've got 2 study tours taking place in the week running up to the midterms between the 3rd and the 9th of November, one going through Pennsylvania going to Philadelphia and then DC and then into Virginia. And I'd love to talk about the court. Then we're also going to Florida and Georgia as well. So I'm very keen to know a bit more about DeSantis' ruling there as well. Timely, very timely. Hilary Matthews, a good pertinent question, and it's really along the line of my one too. So the degree of pessimism there. Go ahead, Hilary.
Yeah, I suppose it's a little bit along the lines of you're saying, what can we do about the Roe versus Wade ban? But I'm thinking about even if the Supreme Court upheld any kind of ban on weapons, what difference would it make? With more weapons than people in the US, even if guns were totally banned tomorrow, it would make no difference. I haven't heard anybody talk to that. In a perfect world, take off your legal hat, or perhaps you'd need it still. What solution is possible to reduce gun violence in the States? Because you can't get rid of the guns, they're there.
And Hilary, as we've just been discussing as well, the states just told the states they can't impose extra restrictions on guns. David.
So yeah, I know. Look, that is a huge problem. The existence of 400 million guns, more guns than there are people in this country, is a huge problem. And guns, unlike laptops and cell phones, work for decades and decades and decades. So they don't actually go. They don't sort of fall into to trash. They're usable for a very long time. So it's a serious problem. That said, can you do something about it? Absolutely, you can do something about it. You can put very serious restrictions on people carrying guns in public, and then it makes it people are a lot less likely to carry guns in public. You can have buyback programs like Australia and Canada have had when they sought to responded to mass shootings and decided to not only let's restrict access to guns, but let's actually buy back. Let's take a lot of these guns off the market. Are we there politically in the United States? No. But we're actually moving in the direction of more openness to gun regulation, in part out of the just sheer horrificness of these mass shootings that we increasingly suffer, and in part because the NRA has become much less powerful. It's had its own internecine problems. It's had a lot of corruption. Its leader was found to have, stolen a lot of money, et cetera. And so the NRA is a lot less powerful than it used to be. And that was a real sort of block on any kind of reasonable gun regulation. And I will say, those who favor gun regulation have used their civil liberties and created grassroots organizations across this country, including something called Everytown for Gun Safety, to match what the NRA did. So it's an instance of people who care, using their civil liberties in a democracy to pursue the values that they care about. And if you do that over time, you can succeed. And if you don't do that, there's no chance.
David, we've just got to wrap up, but very briefly, do you think these decisions by the Supreme Court are going to have an impact at the polls? I mean, do you think that the people who support your work, and they're going to be Democrats, are more likely to be turning out at the polls? Is there a political effect from this?
I certainly hope there is. And I think that's one of the most effective ways for people to express their unhappiness with what the court has done. And one of the most effective ways to push back is you vote for people who care about the values that you care about, and you get them in office, and then they can enact laws that will do that, and that will over time affect constitutional law as well.
Well, David, thank you very much. It's been a really good discussion, enlightening, and going back into history as well. Thank you very much indeed for your time. It's been a really good hour. Thank you very much.
Well, thank you so much for having me. Bye-bye.